One.
Good afternoon, and thank you for joining us for today's National Conference of State Legislatures webinar, State Legislative Trends in Traffic Safety. My name is Douglas Shinkle, Transportation Program Director at NCSL, and I'll be your moderator for today. This is the fourth webinar in NCSL's Natural Resources and Infrastructure Committee Spring Webinar Series. We have a total of 5 webinars lined up in this series, which you can see on this slide. Topics from the past few weeks include examining how states are determining their energy transmission portfolios, a review of the new Waters of the United States rule and how states are responding to those jurisdictional changes, and an analysis of solar power on agricultural lands while preserving pollinator habitat and soil health. 2 weeks from now, there will be a webinar looking at how states are meeting clean air standards as they deal with an increase in emissions from exceptional events. For a complete schedule and registration details, please visit our website at www.ncsl.org. Before I introduce our speakers, I want to review a few housekeeping items. Today's webinar is a platform for information exchange and engagement. Over the next 60 minutes, we encourage participation through our chat box, so please feel free to type your questions and answer any questions in the chat box on your lower left screen. Look for audience chat. To begin building some comfortability with the chat function and also learn who has joined us today, please type the state from which you are calling now, and we'll see your name when you do so. And appreciate that. We will hold a formal Q&A after our presenters are finished presenting. So as questions occur to you, please type them in the chat function, and we will try our best to answer them. I want to briefly mention the resources. Above the presentation, you'll see a couple tabs with one of them labeled resources. Here you can find and download a PDF version of the PowerPoint as well as some other handouts. Our webinar today is being recorded, and registrants will be able to access a recording of the webinar and presentation slides on NCSL's website after the webinar completes. We will send out a notice once those resources are made available. You should also see another tab labeled Speaker, where you can read the bio of today's speakers. You can access these tabs at any time during the presentation. The webinar platform we are using is optimized for use in Google Chrome. So while other browsers may work, we recommend you using Chrome, especially if you're having any issues. If you continue to have technical issues, please email registration@ncsl.org, where our team is ready to assist you. So very quickly, for those of you who don't know, NCSL stands for the National Conference of State Legislatures. We are a membership-based organization providing services for all 50 state legislatures and territories and the 7,000 plus legislators and 30,000 plus legislative staff. We're here to provide bipartisan research, provide opportunities for peers to meet and learn about what is and isn't working in their states. This webinar is supported via NCSL's long-term cooperative agreement with the National Highway Traffic Safety Administration, NHTSA, which allows NCSL to assist state legislatures with traffic safety research, technical assistance, and peer-to-peer exchange. This partnership enables NCSL to compile and keep apprised of the latest developments related to traffic safety in state legislatures. Our flagship resource that underpins most of our traffic safety research is our Traffic Safety Legislative Database, which can be seen on the current slide. This database is available to the general public and enables users to search for traffic safety related bills between 2007 and 2020 across 15 topic categories. There is also a keyword search function, so I do encourage you to check that out if you're also not already familiar with. So now let's dive into that webinar, which is really a sneak peek at our upcoming annual Traffic Safety Trends Report. NCSL does this every year, and for this year, we'll be summarizing the notable enacted traffic safety legislation from last year, 2019. We expect that report to be ready in the next month or two. We're getting very close to being done. My colleague Samantha Bloch and I will review how state legislatures are responding to the 37,000 or so deaths that occur on American roadways each year. After NCSL's presentation, Joe DeLorenzo with the Federal Motor Carrier Safety Administration will discuss how states can utilize their new drug and alcohol clearinghouse to help ensure commercial and school bus drivers do not have previous impaired driving violations, and to help prevent such individuals from getting other driving jobs that require a commercial driver's license, CDL. Once we've heard from Joe, we will dive into the Q&A. So first up, we have my colleague Samantha Bloch, who will provide an overview of impaired and distracted driving, seatbelts and child passenger safety, and driver's licensing legislative trends. We were thrilled to have Samantha join NCSL's team last August. Samantha is a policy analyst in NCSL's transportation program, working on our traffic safety and 911 portfolio. Before joining NCSL, Samantha worked as a legal consultant for the Organization of Economic Cooperation and Development's Anti-Corruption Division. Samantha holds a double degree in law and economics and a master's in law and American law practice from the University of Denver. She has lived in 6 countries on 4 continents and is fluent in Spanish, French, German, and English. And so thank you, Samantha. The floor is yours.
Thank you, Doug, and good afternoon, everyone. As Doug mentioned, I'm going to discuss state legislative trends in impaired and distracted driving, occupant protection, and driver's licenses. Let's turn to impaired driving. Impaired driving fatalities account for roughly 1/3 of all traffic fatalities, and impaired driving remains a complex and persistent traffic safety and public health issue for states. In 2019, 49 states enacted approximately 140 bills regarding alcohol and drug impaired driving. The 3 areas where we observed the most legislative activity concern ignition interlock devices, implied consent and testing laws, and 24/7 sobriety monitoring programs and treatment programs. I will address these in more detail in the next slides, but I want to give you first a quick update on other main legislative topics. Regarding restricted driving privileges of driving under the influence offenders, Nebraska now allows drivers with a restricted school permit to not only drive to school buildings, but also to other property used by schools for extracurricular activities, for example. Oregon's new law allows holders of restricted licenses to drive when they need necessary services for themselves or their families. And the law specifies that necessary services are not limited to basic necessities. Regarding sealing and expungement of records, North Dakota and Vermont expanded the numbers of crimes that can be sealed and included some DUI offenses. On the contrary, Delaware, Mississippi, Utah, and West Virginia reformed their expungement regime but explicitly excluded all or certain DUI offenses. A significant trend in 2019 was penalty enhancements for driving under the influence of alcohol or drugs offenses. Hawaii, Indiana, Maryland, Texas, and Virginia enhanced penalties for driving under the influence of alcohol and or drugs. In Hawaii and Maryland, for example, fines can be of up to $5,000 for repeat offenders. Only one state, New Jersey, eliminated enhanced penalties for DUI offenses that occurred on school property or crossings. Reporting and data collection are critical to understanding the scope of the impaired driving problem. However, as NHTSA points out, reporting across states and jurisdictions is not uniform, especially regarding drug-impaired driving. In this regard, California, Illinois, and Maine passed legislation aimed at improving data collection and reporting of driving under the influence of alcohol or drug offenses. New Jersey enacted a bill related to collecting and reporting of ignition interlock device data. Regarding ignition interlock installation requirements, compliance laws, and indigent programs, there were at least 8 states in 2019 that enacted legislation regarding ignition interlock device installation requirements for DUI offenders. The most noteworthy development in this regard is that Kentucky and New Jersey now require or strongly encourage all DUI offenders to install ignition interlock devices. Previously, only recidivists and offenders with a high blood alcohol content had to install such a device. Louisiana and Oklahoma now provide the opportunity for individuals with suspended driver's licenses to install ignition interlock devices in their vehicles so they are allowed to drive. Kentucky and Texas strengthened their indigent programs by allowing additional fee waivers or steeper fee discounts for defendants that are unable to pay ignition interlock device costs. And finally, Idaho, Kentucky, and Maryland amended their laws to require ignition interlock devices to be camera equipped. As you can see in the map, as of the end of 2019, a total of 21 states, represented in turquoise or light blue in the map, require IDDs to be equipped with a camera. And I'm now turning to implied consent and testing laws. There were 11 states that changed their implied consent laws in 2019. For example, South Dakota amended its commercial driving implied consent law to include blood and other bodily substances tests. Similarly, North Dakota included the testing of saliva. Tennessee added blood tests to its implied consent law for determining alcohol and/or drug impairment. In a more novel approach, Alabama included remote drivers of autonomous vehicles in its implied consent law. Under the new law, these drivers are subject to blood, breath, and urine tests to determine alcohol or drug impairment. Let's turn now to the 24/7 sobriety monitoring programs and treatment programs. In an important trend, several states enacted bills concerning 24/7 sobriety monitoring programs or treatment programs in 2019. 24/7 sobriety programs are programs that hold offenders accountable by submitting them, usually to alcohol and or drug tests every day, twice a day for a certain period of time. Research shows that they are promising and cost-effective. Nevada created a new statewide 24/7 sobriety and drug monitoring program last year. Currently, 14 states have 24/7 sobriety monitoring programs or pilot programs at the state or county level. And you can see this in the map. Iowa, Montana, North Dakota, and Wyoming amended their 24/7 sobriety monitoring programs in 2019 to broaden access to the program or fine-tune program requirements such as minimum participation periods and testing methods. Montana, for example, allowed hardship testing methods that include use of transdermal alcohol monitoring devices and remote breath test devices to facilitate testing for participants for which twice-a-day visits to testing centers can be very difficult and expensive. Other states, including Mississippi, Oklahoma, Vermont, adopted legislation focused on alcohol and drug rehabilitation. Distracted driving is a growing traffic safety concern. NHTSA estimates that about 3,000 people died in distraction driving affected crashes in 2018. However, traffic safety specialists largely agree that because it is very difficult to identify distraction as the cause of a crash, this number undercounts distracted driving fatalities. In 2019, 5 states enacted handheld bans. These bans are bans that prohibit drivers from holding their phones in their hands while driving, but generally allow hands-free use when the device is activated by voice or a single tap or swipe. I was able to catalog enacted laws in 2020 regarding distracted driving, and I observed that despite shortened or disrupted legislative sessions, the topic was high on several legislatures' agendas. So far, 4 states have enacted handheld bans in 2020. Currently, 25 states, the District of Columbia, Guam, Puerto Rico, and the U.S. Virgin Islands have primary enforcement laws that ban handheld electronic personal device use for all drivers. As a side note, I want to quickly mention that primary enforcement laws are laws that can be enforced without any other offense taking place, and secondary enforcement laws can be enforced only if the driver also committed a primary violation at the same time. Of the states without a handheld ban, 21 have primary enforcement texting bans for all drivers. Arizona and Florida changed their texting ban for all drivers from secondary to primary enforcement law in 2019. Ohio and Nebraska have secondary enforcement texting bans, although Ohio has a pending bill that would impose a handheld ban if enacted. Missouri has a primary enforcement texting ban for drivers under 21 only, and Montana has no bans. Some other trends regarding distracted driving include imposing all mobile device bans for novice drivers. In 2019, Arkansas and Tennessee enacted such bans for drivers under 18, and in total, about 38 states plus DC have all mobile device bans for drivers under a certain age or with a beginner permit. Distracted driving laws usually carry a variety of penalties, and in 2019, states imposed monetary fines ranging from $50 to $275. In Illinois, there is a minimum fine of $1,000 and a mandatory driver's license suspension of 1 year when a violation results in great bodily harm. Other penalties are point assessments, temporary disqualification from receiving a commercial driver's license, and auto insurance surcharges. Especially noteworthy 2019 enactment was made by Florida. Florida enacted legislation requiring law enforcement officers to record the race and ethnicity of individuals receiving a citation for violating its texting or school and work zone handheld ban, aiming to prevent racial profiling. Let's turn now to adult seatbelt laws. NHTSA research shows that wearing a seatbelt reduces the risk of fatal injury by almost half for passenger car occupants and by more than half for occupants of light trucks and vans. While the national adult front seatbelt use rate increased to over 90%, progress has been particularly lacking regarding rear seatbelt use. In 2019, 4 states enacted laws concerning seatbelt requirements. Maine now authorizes passengers that are 18 years and older to not wear a seatbelt if the number of passengers exceeds the vehicle's seating capacity and all the seatbelts are in use. Alabama amended its seatbelt laws to include backseat occupants. Alabama already had a primary enforcement law for front seat occupants, and the new law is a secondary enforcement law for the rear seat. New York also passed legislation to include backseat occupants in their primary enforcement law, but the bill has not yet been signed by the governor. This map shows adult seatbelt laws in all 50 U.S. states and territories as of December 2019. Research affirms that seatbelt laws significantly increase seatbelt use and that primary enforcement laws are more effective than secondary enforcement laws in doing so. As you can see, 26 states require seatbelt use for all occupants, and 19 of these laws are primary enforcement laws. 19 states only require seatbelt use in the front seat. New Hampshire and American Samoa are the only state and territory without a seatbelt law for adults. However, New Hampshire has pending legislation and is considering a secondary adult seatbelt laws for all seats. I wanted to note quickly that there is a growing interest in researching whether seatbelt use is lower for hire vehicles than in personal vehicles, and some research suggests that it is. And New York, for example, recently amended its seatbelt law to require passengers older than 16 to buckle up in the back seat of for hire vehicles. Previously, only passengers in the front seat were required to do so. Let's turn now to child passenger safety. NHTSA estimates that car seats and booster seats reduce fatal injury by 71% in passenger cars for infants under 1 year old and by 54% for toddlers ages 1 to 4. All 50 states, the District of Columbia, and the U.S. territories have some form of child safety seat law. In 2019, 4 states enacted child passenger protection legislation. NHTSA recommends that the youngest children should be kept in the back seat in rear-facing car seats for as long as possible, and experts agree that this should be at least until age 2. Louisiana, Washington, and Maine joined 12 other states and now require rear-facing seats until age 2. This map shows that the states that had such a requirement as of the end of last year. Louisiana, Washington, and Maine also strengthened their child safety laws regarding forward-facing and booster seat requirements, as well as seatbelt requirements for older children to align them more closely to expert recommendations. And finally, I want to talk to you about driver's license suspensions, revocations, and restoration. Driver's license suspensions and revocations were a widely debated subject in 2019. 6 states added new driving offenses, such as refusing to submit to an impairment test as a basis for driver's license suspension, or increased suspension periods when violations caused serious injuries. 4 states reduced suspension periods for certain driving offenses under certain circumstances. For example, when offenders agreed to participate in the state treatment and job program, or reduced penalties for driving with a suspended license. We observed a particularly important trend regarding suspension for non-payment of fines and fees, independently of whether the underlying offense was a moving violation or not. A moving violation is any violation of the law committed by the driver of a vehicle while the vehicle is in motion. 9 states repealed provisions authorizing driver's license suspension for non-payment of fines and fees, or amended their laws to allow for extended pay periods, reductions, waivers, or alternative penalties. I will now turn it over to my colleague Doug, and he will discuss traffic safety trends related to bicycle safety, electric bikes, and electric scooters, school bus safety, automated enforcement, and lowering speed limits. Thank you.
Thank you, Samantha. I really appreciate it. Great job, and looking forward to, please do input some questions as they come to you, and let's dive right in with my content. So every school day, more than 25 million children climb into nearly 500,000 school buses around the country to take them to and from school and related activities. Recent tragic school bus crashes in Indiana, Tennessee, New Jersey, Iowa, to name a few, have sparked lots of debate at state houses and a slew of new school bus safety laws and programs. This map that you see here on this side focuses on 2 particular school bus laws. Stop arm cameras and seatbelts. States in blue allow stop arm cameras, which I'll go into a little more what that means. States in yellow require seatbelts on large school buses, and 2 states, Arkansas and New York, have both such laws. Let's first discuss stop arm cameras. So instances of motorists illegally passing a stop school bus are more commonplace than one might imagine. There's an annual survey conducted to gauge how often this dangerous driving action takes place. For the 2019 survey done by the National Association of State Directors of Pupil Transportation Services, over 131,000 school bus drivers participated from 39 states, and they recorded over 95,000 drivers illegally passing a school bus in a single day. And then note that 102 students under 18 walking or on bikes were killed in school transportation-related crashes between 2008 and 2017. Most states do require vehicles on both sides of a road without a median to stop and remain stopped while school bus stop arms and flashing red lights are deployed. And now 22 states explicitly allow local governments or school districts to use cameras to capture images and issue tickets for drivers illegally passing stopped school buses. Those cameras are typically situated actually on the stop arm or somewhere nearby, and they're meant to record specifically just that kind of violation. The National Transportation Safety Board, is part of an investigation into a school bus crash that took the lives of 3 Indiana school children, recommended the remaining 28 states without such laws adopt them. 7 states did enact laws in 2019 allowing these stop arm cameras to be used in their states. Our trends report will go into significant detail regarding these laws. They do vary widely in terms of fine amounts and the process to review and cite infractions, etc. So keep an eye out for that. Let's now talk about school bus seatbelts. School buses are designed to be safer than passenger vehicles in avoiding crashes and preventing injury through compartmentalization, which includes closely spaced seats and those high energy absorbing seat backs that we perhaps remember from elementary or middle school. 8 states that you can see on the map have laws requiring the installation of seatbelts on school buses. However, Arkansas, Louisiana, and Texas's laws are subject to appropriations or approval or denial by local jurisdictions, so they don't really have the teeth of a statewide requirement. In May 2018, NTSB did recommend that states enact such laws to require that all new large school buses be equipped with passenger lap/shoulder belts for all passenger seating positions. No states enacted a new seatbelt requirement in 2019, although 13 states did consider them. However, Iowa's Board of Education recently approved an education department rule requiring 3-point lap shoulder belts to be installed in all new buses effective October of 2019. So state and automated enforcement laws, and what we're talking about is red light and speed cameras, and these are obviously controversial. They can come with some baggage for sure. Generally, the research shows them to be effective. According to the Insurance Institute for Highway Safety, IIHS, who does great work on this and many other issues, as of June 2020, there are 340 city and local governments in 22 states that use red light cameras. The big news in 2019 was definitely Texas banning red light cameras in their state, something Texas lawmakers have been trying to do since 2007. The governor cited concerns that the cameras pose constitutional issues because individuals are not able to confront their accuser in court. Also in 2019, Hawaii enacted legislation establishing a red light running committee to develop policy recommendations for red light camera pilot programs in Honolulu, Maui, Kauai, and Hawaii counties. Let's now talk about speed cameras. So speed cameras less utilized in terms of the number of communities. 153 communities in 16 states and DC currently have them. 2019 was an active year for speed cameras in the New York legislature. They passed a bill establishing a speed camera demonstration program in school zones in Buffalo. Drivers traveling more than 10 miles per hour above the speed limit in the school zone will be fined, with fines capped at $50 for each violation. Additionally, in really big news, the New York legislature expanded New York City's school zone speed camera program, allowing cameras around every public elementary, middle, and high school in the city, a city of 8 million people. The law also allows the cameras to operate for longer hours each day. This authorization to utilize cameras in 750 school zones will make New York City's speed camera program the largest in the United States. It is worth noting that some states do explicitly prohibit speed or red light cameras. Maine, Mississippi, New Hampshire, South Carolina, Texas, and West Virginia prohibit both red light and speed cameras. Montana and South Dakota prohibit red light cameras, and New Jersey and Wisconsin do not allow speed cameras. Let's now talk about lowering speed limits. So a few miles per hour can make a world of difference for a pedestrian or bicyclist who is struck by a vehicle. Foundational AAA research from 2011 found that the average risk of death for a pedestrian in a collision with a vehicle is 10% at an impact speed of 23 miles per hour. It's 25% at 32 miles per hour, and then it jumps to 50% at 42 miles per hour. In the past decade, at least 7 states had given localities some level of increased flexibility to reduce minimum speeds on roadways within their jurisdictions. And in 2019, 6 more states did so: Hawaii, Michigan, Minnesota, Montana, New Jersey, and North Carolina, while New York and Oregon further revised some changes they'd made earlier in the decade. A few notable examples from 2019 include the Oregon legislature expanded on a bill passed in 2011. That bill allowed Portland to reduce their speed limit by 5 miles per hour on highways within their jurisdiction and extended this provision to other cities in the state, provided they are not an arterial highway or located in a residence district and proper signage is posted. It might be worth mentioning that it can be very onerous to get these speed limits lowered on roads within municipalities, depending on if it's owned and managed by the state DOT. And really, a lot of these laws are around giving more flexibilities to localities. Minnesota allowed cities to set speed limits on streets under their jurisdiction without undergoing an engineering and traffic study, Montana expanded the ability for the state to establish special speed zones. Previously, those zones had to be less than 50 miles in length, but the new law allows special speed zones on highway corridors with increased crash frequency. Additionally, Montana amended their process to allow greater flexibility for county commissioners to set school zone speed limits, provided the limit is no lower than 15 miles per hour. Texas also revised their process for setting speed limits in school zones in 2019. So let's next talk about bicyclist safety a little bit. According to a 2015 IIHS analysis of bicycle crashes between 2008 and 2012, 9% of bicycle crashes and 45% of the more than 3,300 bicyclist deaths in that time period occurred as a result of a vehicle hitting the bicyclist from behind or the side while traveling in the same direction. There is a NHTSA study in the works to examine the effectiveness of such laws in increasing passing distance, and it'll be interesting to see what that says. In 1973, Wisconsin became the first state to enact a safe bicycle passing law. As of today, 33 states and DC have enacted passing laws that require the motorist to leave at least 3 feet or more when passing a bicyclist. 2 states have laws that go beyond a 3 feet passing law. Pennsylvania has a 4 feet passing law, and South Dakota requires 3 feet when passing on roads with a speed limit of 35 miles per hour or less, and a minimum of 6 feet for roads with speed limits greater than 35 miles per hour. Additionally, a new trend that we're seeing is that 5 states, Delaware, Kentucky, Nevada, Oklahoma, and Washington, require a motorist to completely change lanes when passing a bicyclist if there is more than one lane proceeding in the same direction. Let's talk a little bit about electric bicycles, which I think is something that more people are becoming familiar with. 13 states enacted bills related to e-bikes in 2019. 11 states established a 3-tiered e-bike classification system. You can see that 3-tiered definition on the right hand of that slide. Class 1 and Class 3 are pedal assist, meaning the rider must be pedaling to activate the motor. It doesn't work otherwise. You can still, Class 2 is not pedal assist, but the motor ceases to provide assistance at 20 miles per hour. There are now 22 states with this 3-tiered definition for electric bikes, indicated by yellow in the map. States in green define e-bikes but do not have the 3-tiered definition. Hawaii went with the federal definition, while New Jersey created a 2-tier definition. 6 states in 2019 enacted legislation requiring e-bike operators and passengers to wear bicycle helmets if they do not meet minimum age requirements. Those were typically in the 18 or 16 range. 10 states' laws included e-bike age restrictions for certain riders. Same thing, if you can't actually ride a certain e-bike, oftentimes a Class 3, unless you're a certain age. One of the primary rationales for states to enact e-bike legislation is to differentiate e-bikes from other motorized devices such as mopeds and motorcycles, and exempt e-bike operators from licensure and registration requirements. The new laws in 11 states include such language. And my last slide, electric scooters are probably something that a lot of folks became more familiar with in the last couple of years. They went certainly from oddity to reality in numerous cities across the U.S. in 2018 and 19. According to a 2019 report from the National Association of City Transportation Officials, NACTO, there were 38.5 million e-scooter rides in the U.S. in 2018, the year with the most recent data available. That compares to nearly 0 rides in 2017 before scooter share companies unveiled their services in U.S. cities. This map shows states that define e-scooters. In 2019, 19 states in blue enacted legislation addressing e-scooters. 4 other states, the ones in yellow, had e-scooter laws predating 2019, although Washington did add to their law in 2019. 10 states have a minimum operator age for riders, with 7 states setting age 16 as the youngest age possible to operate an e-scooter. Utah, on the other hand, set the age limit at age 8, and 12 states have no defined age limit for e-scooter operators. Every state except Kansas established maximum operating speeds for e-scooters. The maximum operating speeds range from 15 miles per hour in Arkansas, Utah, Washington, and Wisconsin to 19 miles per hour in New Jersey and 20 miles per hour in most other states. Oregon, which has the highest e-scooter speed limit of any state, 24 miles per hour, is the only state to require all scooter riders to wear helmets. 4 other states mandate helmets for minor riders, while the remaining e-scooter laws do not require helmets. And so that concludes my presentation. Thanks to Samantha and to all of you for listening. We do have a variety of resources that go into further depth on some of the things that we talked today, so feel free to reach out to us afterwards to our email and let us know what you're interested in. Thank you for listening. Please do send us some questions, and we will respond after the next speaker, who is Joe. So I will turn it over to Joe, mute my phone, and it's all yours, Joe. Oh, hold on, Joe. Let me actually introduce you. That would probably be polite. We're quite excited to have Joe with us. He's with the Federal Motor Carrier Safety Administration. He graciously agreed to join us for this webinar to provide an overview of an important new traffic safety tool, their new Drug and Alcohol Clearinghouse. Mr. DeLorenzo is the Acting Associate Administrator for Enforcement for the Federal Motor Carrier Safety Administration. He is responsible for policy and program development for the agency's enforcement and compliance program. He has been with FMCSA for over 25 years. And with that, I will turn it over to you, Joe. Thank you very much.
Sure, Doug. Thanks. I appreciate that, and I appreciate you all having me here today. I'll just quickly walk through a couple of things on the Drug and Alcohol Clearinghouse. It's really a fantastic new tool that we have to help with safety on our roadways. And what the clearinghouse does for us in general is it really gives us real-time access to drug and alcohol reporting information and makes it easier on employers, law enforcement, and everyone else to identify those drug and alcohol violations, and much harder for a commercial driver to operate while they have some kind of drug and alcohol issue that has been detected. And I'll talk a little bit more kind of about what that means in real terms here on this next part of the discussion. But just to kind of frame this for everyone, there's about 4 million CDL drivers in the U.S. And a lot of times when we talk about CDL drivers, folks are thinking kind of traditional large truck drivers, which certainly is included in that category. However, there's a unique part of our regulations, and the commercial driver's license regulations and the drug and alcohol regulations both apply to both inter and intrastate drivers that hold those licenses. So that also includes some more non-traditional types of folks that we don't often interact with. That includes municipal operators like snowplow drivers, school bus drivers, who are also and have been subject to the drug and alcohol regulations, but now have to have direct interaction with the Drug and Alcohol Clearinghouse. And the biggest gap that the clearinghouse helps us to fill is a driver who applies for a job and takes a pre-employment drug test and fails. Before the clearinghouse, that driver could just go hang out, wait it out for a couple of weeks, and then go back and reapply, get a negative test, and move on, and no one knows that other positive test occurred. With the clearinghouse, those positive test results are entered directly into the clearinghouse by the medical review officer, so it's not relying on the driver or the employer to report, but the medical review officer that makes that final determination enters that information into the clearinghouse, and then it's there, and the next employer, when they check the clearinghouse as required, they will see that positive test result, and that driver will be prohibited from driving until they complete the entire return to duty process. It really centralizes all the information. It also pushes information about a driver's eligibility to drive out to the roadside to law enforcement, and allows us to manage that data in a way that we really haven't been able to see it before. The rule came about as a result of act of Congress and was put into place just January 6th of this year, so we're just closing in about 2 days away from 6 months, a full half year of data going into the clearinghouse. And there's also a second companion rule to this, and that relates to the licensing process itself. When I described the scenario earlier, I was talking about drivers that are already licensed. They're putting the information is getting put in there. But this new rule that is out there for public comment right now will have an effect on the issuance of the license, whether it be issuing, renewing, upgrading, whatever, with a CDL. If a driver has a drug and alcohol violation, that will be getting pushed to the licensing agency and will allow the licensing agency to not issue that license because of that open violation. So that's a second and also very important piece of the puzzle in terms of eliminating the ability for a driver to operate when they've had a drug and alcohol violation. So again, just to kind of reiterate, the user base for this is not only the driver. The driver does have to, when they go to apply for a new job, they will have to have an account because their CDL has to be in there and be verified, and also they will have to respond and affirmatively allow an employer to query their information to protect their private information so that anybody can't see it, only those employers that are granted access by the driver to do that. The employers, of course, have to have access to that to do queries and things like that. And then there's the medical community, the third-party administrators, those folks that run a drug testing program for a carrier or for a group of carriers, the medical review officers I mentioned earlier who verify the final results and establish that a result was positive, and also the substance abuse professionals. I mentioned briefly earlier that a driver is prohibited from driving until they go through the return to duty process. The SAPs, the substance abuse professionals, are key in that process, and all of this has to happen in the clearinghouse because that's the one central repository. So once the driver completes that, the substance abuse professional will certify that in the clearinghouse. Driver gets a negative pre-employment test, that's all in there, and then they'll be okay to drive. A driver that tests positive, if they close that out and go through that entire process of return to duty and then are back eligible again, that information will remain in the clearinghouse for 5 years, and then it will disappear with no additional violations. However, if a driver doesn't close that out and never completes the return to duty process, that information will remain in there forever. So if they ever go to apply for another job, that will be available for the employer, and they would be prohibited from driving until they completed that return to duty process. So a super important part of the whole process is kind of a soup to nuts. How do you address that violation once it occurs? So as far as what's actually happened in there, I mentioned this briefly earlier, but all the information is in there. The driver agrees to a query. The company does the query and maintains that documentation. And it's not just a pre-employment query. I may have this on another slide, but I'll mention it here as well. There's also an annual query. So once a year, the company will query all of their drivers, just in case that driver went out at some point in time and applied for a job with another company and took a pre-employment query without pre-employment test and failed it without telling that employer. That would get picked up during the annual query. And I also will note there is a small charge per query. It's $1.25 per query. For the carriers, and large users can buy an unlimited package, but most people are buying regular query packages centered around that $1.25. So a couple key highlights of the rule. I think I mentioned this earlier, but it is really one of the most important parts, and that is the push to roadside. Interestingly enough, even with very little information, I think it was about 2 weeks before we caught our first driver at the roadside that was still operating while they had a positive test in the clearinghouse that had not been resolved. So really a key piece, and it will get more and more powerful as time goes on and more information is entered into the clearinghouse because there was no information entered for the time period prior to January 6th. It was a as we go forward type of rule for a lot of different reasons. So the more time that goes by, the more data we get, the more positive results get put in there, the more powerful the clearinghouse gets, and the more we learn about the trends in the industry, what drugs are coming up positive, how often those things are happening, how many drivers are completing the return to duty process and how many aren't. All of that information that we just didn't have available before, that will be really super important as we go forward and improving road safety and identifying pending trends on drug and alcohol use and things along those lines. This just gives you an idea of the scope of where we are right now. In the clearinghouse, as of June 1st, we had passed over 1 million users. We still have a ways to go. It says 35,000 drivers being registered. I did mention there's 4 million drivers, but also note that the only time a driver needs to be registered is once they decide to apply for a new job. If they're sitting at the company they're able to keep on moving or keep on working for that company. They don't need to apply for an account, and they don't have to have an account until such time as they apply for a new job, which is another really important part of this whole process, because it will, again, like I said earlier, it helps to kind of close the loop, and it will give us a lot of information about that we didn't know before about driver and driver turnover, which also has an impact on safety. So that's kind of where we are with registration. There's still several 100,000 carriers that need to be registered before the end of the year, so we will continue to see that number go up significantly. In terms of queries, 900,000, so closing in on 1 million queries, and over 21,000 violations. So that's 21,000 drivers that have tested positive since January 6th, that before the advent of this rule, we didn't know were testing positive. So really strong results there. We were expecting at somewhere between 50 and 60,000. We'll see how that pans out. This year is going to be a little bit of a weird year for the first year because testing is down some due to the economy and trends and things like that because of the current pandemic. But we'll see how things pan out. Already 21,000 different violations have been reported. And just to wrap up, if you're looking for more information, we have a really nice website set up. If you're interested in it, you can sign up for the email updates. There's a ton of FAQs, lots of information out on there. We haven't started yet because we're just getting enough data, but we'll probably be posting data up there monthly to try and make it easily available for folks. Some of those statistics I just shared with you in terms of number of drivers and registered and positives, and maybe some information about the positive tests, what type of tests they were, what types of drugs were testing positive for, things along those lines. So that all of that information is there and available. There's an email address if you needed to send in a question. And with that, I guess I can turn it back to Doug for whatever wrap up or any other questions that we might have.
Yeah, thank you, Joe. I appreciate you taking the time to talk about the clearinghouse. It's certainly a very powerful tool, and the issue that Joe is talking about is something that a lot of states have been grappling with, especially for school bus drivers. One of the issues that I focus on in terms of this jurisdictional jumping and really having a hard time being able to discern and keep up with folks that should, really be ineligible to operate certain vehicles, but they were still being able to be eligible. Joe, I do have a question for you. Is there anything that states can do to kind of help support the state's use and the jurisdictions within the states in using the clearinghouse or supporting driver's licensing agencies? Any thoughts on any of that?
Well, I would say number one would be to the extent that everybody can help get the word out. That's probably number one, because we try to do as best as we can, but there are a lot of folks out there, especially when you start getting down to municipalities and how they're organized. So whatever help we can get on getting the word out to folks that it's out there and being registered, I think that's right now is really the number one thing. We're probably a little bit away, but when we get down to the point of bringing the SDLAs in with the new rule I mentioned, I do think there will be a role there for kind of helping and coordinating through that, because again, as many directions as we can get at this, the better off we'll be. But for now, my ask of everybody that I talk to about this issue is, to the extent you can amplify the message, get it out there and share it through whatever organizations you have with these folks, be it the school buses and stuff like that, that would be really, really helpful to us.
Thank you, Joe. I appreciate your time. And yeah, I think this clearinghouse is just an incredibly important tool, and just keep NCSL in mind as someone to connect with in the future as you get closer to the date when it's mandatory for all states. I did want to ask, and please, registrant participants, first of all, thank you very much for joining us and for staying with us. Please do type in if you have any questions. I want to ask something to my colleague, Samantha. Samantha, given that so many states have legalized medical and recreational marijuana, how are states grappling with that, especially the testing aspect of that? And I'm wondering if you can speak to what some of the research is showing in terms of the kind of impairment mix, the polysubstance impairment issue.
Yes, Doug, thanks. That's a great question. We did receive a lot of research requests last year and at the beginning of this year regarding testing for drugs. And while most states still continue to rely on blood and urine tests for DUID offenses, these tests comes with a lot of inconveniences. For example, there is delays in collection of blood samples, high costs, the invasive nature of blood draws, also the fact that you can detect drugs in the blood or the urine even if the drugs were consumed many days prior. So we had a lot of research requests regarding oral fluid testing, and I know that as of February of 2020, 24 states had statutes authorizing some form of oral fluid or saliva tests, and oral fluid tests allowed to test not only for marijuana, but also for several other drugs, and I know that producers of such tests are looking into what the enforcement officers want these tests to test for. So they're asking enforcement officers what drugs they want to capture in the tests. And this is important because recent research suggests that there is a significant percentage of drivers who test positive for polydrug use. I know that in 2017, 37% of the drivers tested positive for polydrug use. And so this is definitely an important issue and something that I think is of interest to states and will be of interest to states this year and in the next years.
Thank you for that. That was very complete, Samantha. Yeah, I think that's something that we're going to have to be hyper-focused on NCSL. There's increased intention on just trying to figure out how these kind of high-risk impaired drivers that are with a combination of substances. So thanks for that, Samantha. I see a question from the audience, and thank you for that from our friend Laura Beth Long. How are you doing, Laura Beth? You asked, what about safety for road construction crews? Are you aware of any action states are taking related to that, both in general and specifically related to drugs and alcohol? There are a few things I can think of kind of off the top of my head, Laura Beth. I know that many states, well, a good amount of states, probably around 10 to 15, have vulnerable user laws, and they include work and road crews in them. And so essentially there's enhanced penalties if you strike or kill someone. Now, that's more on the back end, kind of trying to send a message and trying to have appropriate justice. It's not really necessarily dealing with preventing such a crash. There were a couple examples. Pennsylvania actually created an automated speed enforcement pilot program specifically for work zones. They created that in 2018, and I believe it just got kind of unveiled and kicked off recently. And so that's one particular example. And there are a number of other states, I'm thinking Maryland and a few others come to mind, that have automated speed enforcement in work zones. There are also things that our states are doing to try and help improve the basically, I think it's called traffic incident management approach. And I can get back to you that, but I'm not super well read on that, but those are some things that come to mind immediately for me.
Doug,
and if there,
also,
yeah.
I didn't see anything specifically related to drugs and alcohol, but Florida and Virginia did enact an all-driver handheld ban in work zones. So that is what I wanted to say regarding distracted driving that was specifically in work zones. But I didn't see any enactments that addressed drug or alcohol impaired driving in work zones.
I appreciate that. Thank you, Samantha. And Brenna, I see your question. Do you have any more information about those penalties, fines for harming construction workers? If you wouldn't mind sending me an email, I can send you what you have, so I can certainly answer that. I unfortunately don't know that off the top of my head. In terms of if we don't have any more questions, I want to again thank Joe for joining us and to Samantha for all her hard work and her helpful overview, and to all of you for participating in today's webinar. The recording of today's webinar and the presentation slides will be available on NCSL's website within a week. Our next webinar will be in 2 weeks on Thursday, June 18th at 3 p.m. Eastern, and will focus on state efforts to meet clean air standards, even as they combat increasing air quality issues due to unusual or naturally occurring events. Speakers will include the Environmental Protection Agency and the Western States Air Resources Council. For registration assistance or questions, please send Kristen Hildreth an email. You can see her email right here on the slide in front of us. And thank you for your continued interest and support of NCSL. I know these are very challenging times personally and professionally, and I just want to express my appreciation for you all participating. I think many of you probably know that we did go ahead and cancel our 2020 Legislative Summit in Indianapolis, but we're hopeful to hold our 2021 Summit in Chicago, and we are planning on convening a traffic safety pre-conference at that legislative summit. So you'll see more information on that, and reach out if you have any questions, and have a great day. Thank you very much.